Okay, now we're going to talk about medical malpractice and arbitration agreements, which is a very popular topic. A lot of insurance companies and physicians are moving into the area of doing arbitration agreements. So in this segment, we're going to talk a little bit about the advantages and disadvantages of doing that in your practice. Basically, what is an arbitration agreement? An arbitration agreement is a contract between the doctor and their patient agreeing that in the event there is any type of dispute, that instead of going to traditional court, an alternative form of dispute resolution known as an arbitration will be done. In an arbitration, there is no jury. There is an arbitrator who is kind of like a judge who will make the final decision of what to do. There's also arbitrations where there are 3 arbitrators, one chosen by each side, and then the third arbitrator chosen by both arbitrators. And you present your case, and it is decided that way instead of through the court system. Now, there are some advantages to arbitration. You get to avoid the jury trial. In the event of a case which is highly emotional that you think people are going to be affected by and may give a huge number, not because of the medicine, but just because of the emotion, you may want to get out of that through an arbitration agreement. So it does avoid that fear of a large jury verdict. Also, you can dictate the terms upon which it is handled. Maybe you want an arbitrator that knows a lot about your particular area. Maybe the arbitrator could be a physician. You can require these type of things in the document. Don't forget, the document is going to be handed to your patient upon the time they come into your visit, and they're going to sign it along with all their intake paperwork. So you're developing this strategy before the lawsuit even happens. It is faster than traditional litigation. You don't have to go through the full couple of years that it normally takes to pursue a lawsuit. Instead, arbitration can happen much faster. Also, there's less attorney's fees and costs. It goes hand in hand with the length of the trial. Normally, if you have a trial, you have discovery, you have depositions, that's a lot of lawyer time. And you got to pay those lawyers. Arbitration is much shorter, hence less lawyers' fees. And the other thing you do is you're going to get rid of probably litigious patients, because they're going to see this document when they come in your office. A lot of them, honestly, are not going to like it. They're not going to enjoy the idea that if something goes wrong, they can't sue you. If people already have that mindset in their head, you're better off them walking as a patient. Even though it sounds good, there are some severe disadvantages. There's no guarantee that the agreement you sign will be enforced. Basically, you're putting together a contract and you're forcing the patient to sign it. They really can't negotiate it. This can go before a judge eventually. What's going to happen is that patient, if something goes wrong, they're going to go to a lawyer. The lawyer is going to go down the traditional path of filing a lawsuit. You're going to come in with your arbitration agreement, and that lawyer's not going to like it. So there's going to be a whole hearing before the judge to determine whether that arbitration agreement is going to be upheld. Also, doctors may prefer juries in some cases. Unfortunately, with these arbitrations, often the plaintiff wants one thing, the defense says something else, and the ultimate solution or resolution is somewhere in the middle. There are some cases where the doctor did absolutely nothing wrong. It may sound bad, but it did nothing wrong, and the doctor is confident that his name will be defended better if a jury gets to hear it, and you don't get that opportunity with an arbitration agreement. So in some cases, like a frivolous case, it's probably better to let you go before a jury. There's also limitations on discovery. Because arbitrations are so fast, there's really not a lot of opportunity to do extensive depositions, extensive discovery, interrogatories. So in the event there's a complex medical case that requires numerous experts, a lot of record review, you're just not going to get it done in an arbitration. With a court proceeding that takes over the course of years, you have that opportunity to look at the case under the microscope. And finally, what I mentioned before, but this is a big problem, is that the arbitrators tend to give a split decision. They're not going to totally go for one side or totally go for the other. They're going to kind of go down the middle. If they're asking for $100,000, you think the case is worth $10,000, there's a good chance it's going to settle in the 50s. With a jury, it's all or nothing. Sometimes you can win. There are defense verdicts all the time. Most of the time, the verdicts are defense verdicts, where 0 is given to the plaintiff. So you do sacrifice that with an arbitration agreement. For our clients, it depends on the particular circumstances. We discuss it with them, and they choose. Anyhow, call anytime, and we can help you out with that. Thanks.